Good morning, everyone. My name is Rahman Mohammed. I'm a senior lecturer at Middlesex University. I'm also a best interest assessor, and I have been teaching the best interest assessors course for a number of years. And my colleague is.
Good morning. My name is Niall Daly. I'm a lecturer at Middlesex, a social worker. My practice background is both in children and families and in adult social care and emergency social work. I've been teaching with Rahman on the BIA course, Best Interest Assessor course at Middlesex for 7 or 8 years now. And I'm very pleased to see you. Well, actually, I can't see you, but I'm very pleased you're here.
Yes, and a great welcome to those of you who have taken time out of your busy schedule at this particular time of the year, when I know at this time of the year you are busy trying to tie up loose ends in preparation for the end of the year when things close down. First of all, introduction to liberty protection safeguards. How important is it? Is it important for your area of practice? Well, in 2021, the NHS Digital, who keeps all of the statistics and monitors DULS applications on behalf of public bodies, actually identified that they had roughly 260 applications for deprivation of liberty under the deprivation of liberty safeguards. Of that, the number of applications that were actually completed was estimated to be 246,000. Surprise, surprise, there were a number of DULS applications that were not completed at all, and those amounted to just about 120,000 applications. So that means 120,000 people were actually deprived of the liberty illegally, potentially. The government estimates that liberty protection safeguards is going to involve an annual application of roughly 300,000 applications under the liberty protection safeguards. So you can see the the parameters within which we are actually talking. It's essentially, this is an estimate which is hopelessly inaccurate, I would add. Um, and we all know from our former prime minister about one of our British former prime ministers, Benjamin Disraeli, who spoke about there being lies, damn lies, and statistics. So I will leave that for you to reflect on. At this point, we are going to ask you to take part in a poll because we want to get an idea as to who we are speaking to this morning. So please take part in the poll. Okay, so I can see 100% of participants are from adult social care. So we are speaking to the converted.
Well, I don't know how many that is, Rahman. It could be just one person's pressing the button. We don't know how many's here. Oh, right. We've got 12% from children's social care.
Okay.
Okay.
All right. So thank you for participating. The number for children's services is going up again. And I'm absolutely delighted to see that a third of participants are from children's services. Thank you very much for participating.
So, Rahman, do we want to mention how we're going to structure this morning?
Yes, please do.
Yeah. So, because this is probably going to be fairly new to a large proportion of you, this is just an introduction to LPS. So we're going to run through the slides, give you some information, and then take questions towards the end, because there'll be lots of things that occur to you as we're going through that might get answered as we talk through the slides, but we'll certainly answer them at the end when we have a question and answer session. So if there's something that occurs to you that you want to know more about as we're going along, if you could just write it down or remember it, and then we can have a question and answer session at the end. We'll leave a good chunk of time at the end of our time this morning.
Yes, thank you for that. So if you haven't voted in the poll, we are ending the poll now. So what are we going to cover today? Now, I had hoped when Niall and I agreed to do this webinar, and to do it in November, I was hoping that we would have some great news to present to you. And we have got some great news to present, but not all of the great news that I was hoping. Now, for today's presentation, there are three pieces of legislation that it's absolutely critical for us to bear in mind. And I know a number of you would already have this, be aware of this, the Mental Capacity Act 2005, the Human Rights Act 1998, that is always in the background, and importantly, the Mental Capacity Amendment Act 2019, which essentially is the act that actually talks about the procedures for liberty protection safeguards that is meant to replace the deprivation of liberty safeguards. What are we going to cover today? We're going to look at some of the differences between LPS and DOLS. We are hoping that at the end of this session, you'll be able to explain to one of your colleagues or many of your colleagues in your teams what the review process is going to involve under liberty protection safeguards, because as you will find out, it's going to draw in fact, all frontline staff in health and social care. And importantly, I'm hoping that you would be able to take this knowledge back and utilize it for your local planning, for how your team, how your organization, your local authority is going to implement the liberty protection safeguards. What we are unfortunately unable to present today is to give you and to tell you that this is the new mental capacity code of practice, and this is what it says should be taking place, and to talk about the training and eligibility of practitioners. We don't have any details on that, but we do have some information that you may find very useful in relation to that as we proceed. So moving on, where are we? At this current time, we know that the Mental Capacity Amendment Act has been amended, has been assented to, and it's ready for implementation. So we are waiting on the implementation start date, which we are hoping will be at some point in the future. This act, the Mental Capacity Amendment Act, it actually repeals DOLS. In other words, it replaces the deprivation of liberty safeguards. And for my colleagues in adult social care and those of you in the children's social care who are aware of it, the deprivation of liberty safeguards was contained in Schedule A1 and 1A of the Mental Health Act 2007 when that was amended. At this current moment, the liberty protection safeguards and the relevant code of practice is yet to be published for public consultation. At the time I prepared this material, I was still hoping that it would be put out for public consultation before later this year. That now looks extremely unlikely, but hold your breath. There are a number of secondary legislation that are needed before the legislation itself can be implemented for LPS. Those haven't been laid in Parliament as yet, and they can't be not until the Code of Practice is actually agreed. So at this current moment, liberty protection safeguards, the best estimate is that this time next year, we will be in the early stages of implementing liberty protection safeguards. I would be pleasantly surprised if it is anything earlier than that, given the current movement that we have. And finally, the good news is that government has already confirmed that for 2 years, the deprivation of liberty system will run alongside or concurrently with the liberty protection safeguards. And you might rightly ask, why would that be? It would be to allow those people who are currently subject to deprivation of liberty under DOLS for that to be transferred over to liberty protection safeguards at the point of a review or renewal. And there might be some people who may no longer need to be under deprivation of liberty safeguards. So that is expected to take roughly 2 years for that to happen completely. So there's going to be that period of transition. And hence, that links in with a point we'll make later on. Okay, so this is where we are now. So deprivation of liberty safeguards is very much still active. We are still running courses for best interest assessors, and actually they are extremely highly subscribed, which is interesting in itself. So let's move on to why you are here. First of all, there are some basic principles for liberty protection safeguards, and colleagues who are familiar with the deprivation of liberty safeguards would notice that these principles are slightly different, whereas DULS was more or less a specialist concern, primarily among adult social care. Deprivation of liberty under LPS has become everyone's business. No longer is it going to be just for specific professionals or just for people involved in adult social care. All professionals involved in the delivery of welfare, involved in what we refer to today as health and social care, needs to be aware of deprivation of liberty and, importantly, to be able to apply Article 5 specifically. Article 5 of the Human Rights Act, which essentially is what is in the European Convention of Human Rights. LPS actually moves the issue about deprivation of liberty not to the end of a process, but very much at the beginning of a process. And so it moves the issues to the front line. LPS is going to be and will be part of the normal assessments that are undertaken before any service is provided to any service user. So that's a major shift. So it means all frontline staff needs to be aware and have some basic knowledge of liberty protection safeguards. The Court of Protection, to whom we used to run to whenever there were issues, there were conflicts, and we were not sure how to proceed, their ability to grant authorizations has now been removed. Their role, however, remains to any challenges made to authorizations that are granted. You might be asking, who is going to be granting these authorizations? Hold on to that thought. I want to keep you at the edge of your seat. The bottom line is that local authorities stroke responsible bodies are the ones who are going to decide authorizations. And by now, the 16 of you who are here, you would be starting to have alarm bells, I suspect, going off in your heads, because it means that the courts are no longer going to decide those troubling, contentious cases. It's going to be a responsible body. And in a lot of cases, it's going to be the local authority. So those are the main principles. Those are like the headlines for you to bear in mind, and why this is so critical, so relevant. So I'm taking it a bit slow because I'm mindful that colleagues from Children's Social Care, especially if you're a frontline practitioner, a lot of what I'm talking about might just be going over your head. So it's important to bear in mind the decision-making sequence that we make in offering any sort of service. And here I'm talking about welfare services in general, offering any sort of health and social care or any sort of arrangements under this term service. So if a service is being offered to a service user at the point when assessment has been completed, and it follows that an assessment has to take place first, if the person is deemed to be lacking mental capacity, then the normal procedures that you would follow when a person lacks mental capacity will be followed, meaning then that any action you take on behalf of that person has to be in their best interests. And particularly if they are objecting, liberty protection safeguards kicks in there in a very forceful way at that particular point. So you can see here that LPS is something that you have to be mindful of from the very point where you are thinking about offering a service. Because as soon as the person lacks mental capacity, you've got to be thinking about what you're going to do. Is it in their best interest? And then you've got to be thinking, am I going to be depriving them of their liberty? And we'll talk about what deprivation of liberty is actually in a moment.
Yeah, and we're talking about lacking mental capacity for specific decisions at specific times. So it's not a global thing. So it's about particular aspects of a care arrangement.
And that's a really good point that Niall has raised there, because we are not this this presentation is based strictly on what the law is telling us. So when we use certain phrases like mental capacity, we are referring to what is meant in the legislation by the term mental capacity, and which Niall has helpfully defined there for you. Thank you very much, Niall. It's amazing how much we take for granted, you know. So moving on, deprivation of liberty. There are three main factors you need to consider when you're thinking about deprivation of liberty. Is the care arrangements, is the service that you're going to be offering, is it actually going to make the person subject to continuous supervision and control, and they will not be free to leave? Where those three factors are in place, they're under continuous supervision, they're under continuous control, they are not free to leave, then that person potentially is deprived of their liberty. In addition, are they lacking capacity? And is the care arrangements being made by a public body, which involves essentially, in the UK context, the NHS and a local authority, or an institution that is regulated by one of the state bodies like CQC or Ofsted, for example. So you can see where, in this case, Cheshire West, as it is called, in reality, it was two court cases in 2014 that actually clarified what a deprivation of liberty is. So essentially, everyone needs to understand, and this is a critical point here going forward, all frontline practitioners need to be aware of what constitutes a deprivation of liberty. So in a step-by-step way, they need to ask, is the person lacking capacity to make decisions about their care and treatment or the care arrangements that are being put in place? Are they under the care of a public body? And public body, as I said, happens to be anything that receives state funding, government funding. And are they under continuous supervision and control and not free to leave? And there's this beautiful quote there from Baroness Hale, the judge involved in these court cases at the Court of Protection. She is now retired, as many of you would know, where she quoted, "A gilded cage is still a cage." So it doesn't really matter what is the purpose that you're depriving that person of their liberty. So that might be an issue that some of you might want to think about. Hold your questions. If you've got any questions, feel free to put it in the chat. In the meantime, we are looking at the chat and we will respond to you either in chat or on air. When does LPS apply? So let's dive into this and stop beating around the bush. When does LPS applies? It applies whenever the arrangements, and this is a new term that Liberty Protection Safeguards under the Mental Capacity Amendment Act 2019 introduces. Under DOLS, we used to talk about care and treatment. The LPS talks about arrangements that amount to a deprivation of liberty. So it means that whoever is offering that service on the front line, they have got to be aware of what is a deprivation of liberty. And here the application is very wide as well under LPS, Liberty Protection Safeguards. No longer is it just restricted to care homes and hospitals. A deprivation of liberty under LPS can happen anywhere, including in your own home. So potentially your partner, or if you're living with your children at a point where you lose mental capacity, potentially they can apply or request. You might find yourself potentially under a deprivation of liberty and requiring input under LPS. There are some additional provisos that has to be decided for LPS to apply, that a deprivation of liberty is necessary and proportionate. And these are two words that will haunt you for the rest of your career in health and social care going forward once LPS is implemented, because those two terms, necessary and proportionate, are used in its legal meaning and not in its layman terminology meanings. LPS applies to anyone age 16 and over. This is a big change from deprivation of liberty safeguards, which only applied to people 18 and over. And the definition for deprivation of liberty that under LPS that is being used remains the same as the Cheshire West ruling of 2014 that I referred to earlier. It's interesting to note that despite repeated requests by different parties and the sector, the health and social care sector, for Parliament to define what is a deprivation of liberty, Parliament refused to do that, preferring to go along with the case law ruling of Cheshire West. So here I've introduced the whole idea of case law, which means that anyone involved in the implementation of liberty protection safeguards, certainly in granting authorizations, would need to be very much up to date with current case law as relates to this issue of deprivation of liberty. So I might be going on at a pace, but I'm just mindful. Feel free to actually plug in your questions, put it in the chat. We are paying attention to them. So liberty protection safeguards covers a whole range of professionals. Staff needs to be aware of the referral process. We need to be mindful of what we mean by the responsible body. Colleagues in adult social care would have known about supervisory body and managing authority before under the old system. We need to become familiar with the assessment process, what that involves. There's a new term introduced that is termed appropriate person. And of course, the role of the IMCA remains independent mental capacity advocate for colleagues in children's social care for whom this term might be unknown. And of course, the AMCP role, the approved mental capacity professional role, that is set to replace the best interest assessors role, is due to commence as well. And importantly, understanding what is meant by a liberty protection safeguards authorization record. So we are going to turn our attention to some of the key points that the legislation makes in relation to these points here. And here, when I refer to the legislation, I'm talking about the Mental Capacity Amendment Act 2019, which I'm sure you can download a copy of and take a look at closely if you so choose. What is meant by the responsible body? Here it is where all change, and perhaps it becomes much more clearer for local authority colleagues here. So the responsible body is the one that authorizes the arrangements. So it's no longer the court of protection that local authorities can go to or the NHS can go to if there's a conflict between the service user or the patient or the family and the institution. It's the responsible body who has to authorize those arrangements. The key point here in the legislation is that where the arrangements for care and or treatment is being made and the person is in the NHS, then the responsible body is going to be the trust. It is likely that NHS trusts might very well be delegating their responsible body responsibilities to individual hospitals, but that's a matter for individual trusts. If the person concerned is age 16 and over and they are in an independent hospital, then the responsible body is the local authority. I don't think that would surprise anyone in local authority. They already do that for patient service users who are under the Mental Health Act. However, if the person their care arrangements falls under continuing health care, then the responsible body is going to be the CCG, Clinical Commissioning Group. This will continue until such time that CCGs are replaced by NHS integrated care services. And that's one of the recommendations in the Health and Care Bill that is currently in Parliament at the report stage. at the committee stage rather. All other sites in the local authority is going to be the responsible body. Now, what do we mean by all other sites? Remember, liberty protection safeguards could take place in supported living, in hostels, in secure accommodation, in your own home, or in a person's own home, which means, therefore, that the local authority is going to be the responsible body for those. So if, for example, the local authority is providing care for someone in their home or in the home of a relative, and that care arrangement or that arrangement amounts to a deprivation of liberty, LPS is going to kick in and it would need to be authorized by the responsible body. The key point to bear in mind here is where the arrangements are taking place. So gone is all those arguments about ordinary residence, etc., etc. It's all about where the arrangements are taking place, not who is paying for it, but where the arrangements are actually taking place. And this would be quite significant for local authorities in London who tend to have a lot of these arrangements externally to London itself. The key point to bear in mind is that a responsible body will not find itself having to essentially follow the authorizations that's been granted by another responsible body. So authorizations are not transferable. So again, you will need to your responsible body to be really clued up and to have their ducks in a row, so to speak, and to be able to monitor these sorts of things that are coming through. If not, they can find themselves perhaps being liable for something if it is missed. So I'm sure there's going to be a question there. So feel free to put in that in the question if you have any questions there. Because I know when we were looking at this, we had quite a lot of debates about this. What does this mean? So we look forward to your questions on that. So moving on, how do you make a referral for LPS? Well, the legislation doesn't actually tell us a formal process, unlike what we found for deprivation of liberty safeguards. And you know, it is described as a fluid process. And we are hoping that the process is going to be fleshed out in the code of practice, which we are expecting to be out for consultation, hopefully before the year is out. So keep your eye on that and do send in your comments and your recommendations when it comes out for public consultation. A range of professionals need to be aware of, as I said, the deprivation of liberty, what that means, what it constitutes, to be aware of the Cheshire West ruling, or what we tend to refer to in jargon terms, the acid test, being under continuous supervision and control and not free to leave, and to be mindful of Article 5 of the Human Rights Act 1998. So you can see here that the referral for LPS is something that responsible bodies have got to be really mindful about. How frontline staff are going to make them aware that someone's deprivation of liberty or potential deprivation of liberty needs to be authorized. So I'm sure responsible bodies are going to have quite an interesting time trying to determine that. The good news for colleagues who are already best interest assessors is that gone are the 6 assessments that best interest assessors are so familiar with. Gone in anything but name, I would add. So essentially, the assessments under LPS involve these 3 assessments. Now, as you can see on the screen, we've got the mental capacity assessment. And this is as per Section 2 and Section 3 of the Mental Capacity Act 2005. Bearing in mind Niall's definition that he gave earlier. Remember, for the Mental Capacity Act to be relevant to a person, they have to be 16 years plus. So you can see, those of us who are BIAs, you can see how technically that first assessment takes consideration of the person's age automatically. Then you have the medical assessment. The The medical assessment, its primary purpose is to determine, does the person have a mental disorder as per Section 1 of the Mental Health Act 1983. And then the third assessment is what is referred to in the legislation as the care arrangements being necessary and proportionate. And that will have to be assessed. So that's called the necessary and proportionate assessment. And that falls under Section 4, which you all know deals with best interests. There's a new subsection that is put in there, Section 4B, in the Amendment Act, and that is what authorizes what we used to know under DOLS as urgent authorizations. But importantly, Section 6 is where the issue about necessary and proportionate assessment actually falls quite neatly as well, because that deals with risk. So those are the three assessments: mental capacity assessment, medical assessment, necessary and proportionate assessment. So best interest assessors would note that actually these three assessments actually cover what was done under the 6 assessments before. So essentially, they have gone, but they are not forgotten. They're very much there still. The assessment process, and I am mindful this must be quite a lot for people to take on. But the assessment process is a 2-tiered process. And there's what is called the pre-authorization process, the things that happen before the responsible body authorizes a deprivation of liberty. So 2 scenarios are possible based on the legislation. You can have the situation where the service involves a deprivation of liberty, but the service user and those that you would need to consult under Section 4 of the Mental Capacity Act, they do not object. And here the papers can be reviewed and a decision taken and a recommendation made to the responsible body to authorize it. Who is going to be responsible for reviewing those papers? And here by papers, I mean the assessments, those 3 assessments that were done earlier that determined that a particular service, a particular care arrangement needed to be put into place. Would it be anyone on the front line? Is it likely to be someone who is going to be a senior manager, senior practitioner, consultant social worker? That is something that we are not clear about. We are not sure if the code of practice is going to specify that or whether that's going to be a local decision. So again, that is something that local authorities in particular will need to be mindful of. If there are NHS colleagues here, NHS Trust would need to be mindful of who is going to make that decision, bearing in mind that any decisions taken there could be challenged at some point, possibly, because people can change their mind. And then what happens if people object? And notice here, at the current moment, we don't exactly know what objection constitutes under this piece of legislation. We are quite clear what objection means under the Mental Health Act. Does it mean someone saying no? Does it mean someone is trying to leave or reject what is being offered? What exactly does it mean? So I suspect there's going to be case law about this, but at this point we could say objection is any indication or communication that the person is not agreeing to this deprivation of liberty. In such a case, whoever has done that initial assessment of that person and has recorded this objection to the arrangements being put in place that amounts to a deprivation of liberty would need to inform the responsible body. The responsible body at that point, and only at that point, will then send on that case to an approved mental capacity professional whose role is then to review the assessments that were done. There cannot be a conflict of interest as there is at the moment. They cannot be involved in day-to-day care or providing treatment for that person. And the approved mental capacity professional has to meet the person, or they can meet the person. They also are obliged to consult with others. That can be other professionals, lasting powers of attorney, whoever, carers, IMCA, etc. And then they will make a recommendation to the responsible body, who will consider it and then decide whether to grant an authorization or not. So this is the pre-authorization process. Let us turn now to the authorization process. The responsible body has the power to grant authorizations. Remember, this was a power that they shared with the Court of Protection previously. Now that they have sole power to grant that authorization. Notice it is not a duty to grant authorization, it's a power. So they have got to use their discretion, because bearing in mind, when a responsible body grants authorization for deprivation of liberty, they are also legally liable. Authorization can start immediately or up to 28 days later. Not much change there. It can be for up to 12 months. And then subsequent to that, if it is reviewed and it needs to be renewed, it can be for up to 12 months in the first instance, and then for up to 3 years, which can be very helpful, especially for people who have those conditions that, it's unlikely that they will ever, regain capacity, as in dementia, for example. The responsible body at that point where they grant that authorization then have to issue an LPS authorization record. Now that record sets out in detail what the arrangements are. It can be arrangements to transport this person from their hostel or from their secure accommodation to a day center, for example. So arrangements can be very broad. But importantly, also the responsible body has to, in writing, document its program for review of these arrangements, how exactly they are going to be monitoring it and reviewing that. The responsible body also, within 72 hours, and the legislation is very clear about this, within 72 hours of granting an authorization to deprive someone of their liberty under LPS, they have got to give a copy of that authorization record to the person concerned who is deprived of their liberty and their appropriate person or the allocated or assigned independent mental capacity advocate. The appropriate person can be any person the person chooses. It can be a friend, a relative. So it's again quite broad. The responsible body, and again, this is a key point here, the responsible body has to ensure that both the person and the appropriate person, who in a sense has taken an interest in the arrangements that is going on under deprivation of liberty, that they understand liberty protection safeguards. And perhaps this is a sting in the tail here, because this is a new duty for responsible bodies, where they have got to make sure that their staff who hands over that authorization record, that they understand what LPS is all about, and they're able to explain what that authorization record actually means. And you can see here where, again, you can have potentially an appropriate person, for example, challenging a deprivation of liberty that's been authorized, saying that it wasn't explained to me, it wasn't explained to my relative, etc., etc., or to my child if it's just under over 16. So interesting times are ahead from a case law point of view, not so interesting if you're going to be caught in that storm. So just on a lighter note, this is the team that's going to be involved in the pre-authorization processes. Essentially, this can be any medical doctor. Gone is the requirement for it to be a psychiatrist under the Mental Health Act, Section 12 doctor. That has gone. It can be any medical doctor, any GP. Doesn't have to be a GP who has a special interest or experience of 3 years or more. Social workers, nurses, no change there. The change has come with the inclusion of speech and language therapists, which I think is going to be really helpful. certainly in NHS settings and local authority settings, occupational therapists, and chartered psychologists. So all these professionals were previously there, with the exception of speech and language therapists. Um, the medical doctors inclusion covers all medical doctors. So once someone is a qualified doctor on the GMC register, they will be able to do medical assessments going forward. So potentially we've got a much wider group of people who will be involved in doing these um, 3 assessments under LPS. So we are coming to the end. You'll be glad to know. Um, the main safeguards of the liberty protection safeguards is that the person has now the right to regular reviews. And you will argue, those of us from adult social care might want to argue that, well, they had that under dolls. They did, but they didn't have a record of when those reviews are going to take place. Now, for the first time, the person will actually have a record of, of, of the program of review, which would include dates as well. The rights of the appropriate person are now safeguarded in law, as well as those of the IMCA. There's no major change there. The big change, though, is that in the right of challenge, the right of the person concerned to challenge that deprivation of liberty, but also the right of the appropriate person. And what is interesting here, and this is specified in the law, is that the legal challenge that they can bring to the court of protection is non-means tested. So in simple terms, they can simply walk up to the court, if that was possible, and say, I want to challenge this deprivation of liberty. And bear in mind also that liberty protection safeguards is starting at the very beginning of a process of care arrangements being put in place, rather than at the end. Potentially, you can see where this is going to be quite an interesting area of practice and case law that we'll need to keep an eye on. The big safeguard as well to keep your eye on is this duty to monitor and report on the liberty protection safeguards to Parliament. Currently, CQC does just that in relation to deprivation of liberty safeguards. They will continue to do that for adults. However, colleagues in children's services, take note, Ofsted is going to be responsible for monitoring and reporting on liberty protection safeguards for those 16 and 17-year-olds that will fall under your care. How exactly this monitoring and reporting is going to be done? I can see the antennas going up and hands going up in the air. How exactly is this going to be done? Especially where this might be happening in settings that are not technically regulated, like in people's care homes, for example, or supported accommodation. So interesting times are ahead. So watch that space. So, and as I promised, we are coming to the end. I think I've got 1 or 2 slides left. These are the regulations or statutory instruments, as they are called, that needs to be passed and, well, laid in Parliament, to use the legal terminology, laid in Parliament and approved. Regulations are required for LPS to actually commence. And as LPS commence, that regulation will indicate that no further dolls are to be granted. It's going to put in place transitional arrangements. Remember, we spoke about that 2-year, that government said it's going to have a 2-year period for transition. It's also going to cover transitional arrangements in relation to BIAs being transferred over to approved mental capacity professionals. It's going to determine, there's going to be regulations about assessments, which assessments can be used, and how decisions can be made in some more detail. There's going to be specific regulations for independent mental capacity advocates under LPS. We know this is quite a general role, IMCA role, so they need to have a special role under LPS. So the regulations are going to say what that is. And importantly, approved mental capacity professionals that's going to be spelled out as well, who those people are going to be, what the training requirements are going to be. As you will note, it's mainly a procedural change. The body of knowledge that a current BIA has, that doesn't change at all. And importantly, statutory regulations are required that would empower Ofsted and the CQC to monitor and report on LPS. So it's quite a bit that is happening and will be happening over the next year. The transitional arrangements mean that no further DOLs can be granted after LPS begins. It means quite significantly that the Court of Protection that in the past would deal with what was referred to as the case of re-ex, and re-ex has to do with what is referred to as it's a very streamlined process that the Court of Protection had, where they dealt with large volumes of cases that were pretty straightforward. So essentially, a court hearing wouldn't be heard, but essentially a judge would sit in chambers and review the paperwork and then make an authorization granting liberty, deprivation of liberty. So that role has essentially been now taken over or been passed over to those responsible bodies. So it's going to be quite a big task for colleagues in responsible bodies compared to what they did previously. So that role is going to be passed on to responsible bodies, local government, CCGs, etc. The code of practice, there's going to be good news. A single code of practice for the Mental Capacity Act 2005 and the Liberty Protection Safeguards, and that's going to be reviewed every 3 years. The status of it, for colleagues who are not familiar with the code of practice and what that means in adult social care, its status remains the same as with the case law of what we refer to as the case of Munjaz 2005, which essentially means that the code of practice is guidance that has to be followed. And you are only allowed to deviate from it only if it is the reference that is used there is if you have a good reason to. And the court would tend to take a very close look at what people consider to be a good reason. So just be mindful of that. You can't just make something up and say, oh, that's a good reason. You can get yourself in some hot water. Okay, so the timeline, I think already I hinted at that. The good news is that LPS commencement will not take place in April 2022, unless Parliament drops everything else that they're doing at this critical point and decides to focus on LPS. That is highly unlikely, although I might be surprised. The regulations, if we are lucky, we might see it in January 2022. It's unlikely simply because the code of practice will have to reflect what's going to be in the regulations. And if the code of practice hasn't been consulted upon, then regulations can't be devised at that point. So that again is a wish list. The draft code of practice is yet to go out for consultation. So the good news for responsible bodies and local authority partners is that LPS commencement is not imminent, certainly not April 2022. And so that provides a brilliant opportunity for all stakeholders to actually begin preparation for the changes to come. I can see Niall smiling there, right? Because I'm sure that's going to mean quite a lot. So what can you do as an attendee in preparation for LPS? And of course, that would depend on your role, wouldn't it, in your organization? If you are a frontline worker, it is critical that you brush up on your understanding of sections 1 to 6 of the Mental Capacity Act 2005. That will not go away. It means you also need to understand and be able to identify what constitutes a deprivation of liberty. It involves you having to potentially do mental capacity assessments at that pre-authorization phase. Because remember, if the service that you're offering amounts to a deprivation of liberty, the responsible body is going to be looking at those 3 assessments. the mental capacity assessments, the best interest assessment that we spoke about, that involves making use of the checklists and the balance sheet. It involves also that necessary and proportionate assessment, which falls under Section 6. It's an opportunity as well to start selecting and preparing staff in relation to those areas that I mentioned earlier, sections 1 to 6, and those 3 assessments. You guys would know best which areas are frontline practice in your organizations. You might want to consider identifying those BIAs within your organizations, including those who have gone and gotten the training by funding themselves. Because the government has actually agreed that they are going to put aside a few million pounds to actually pass on to local authorities to train up those best interest assessors to become approved mental capacity professionals. In the meantime, you might want to think about training up your staff as best interest assessors so that they can easily transition to the AMCP role. As I mentioned, there's no change in the knowledge base that a BIA has for the AMCP role. So that would be a good investment should you decide to do that. There is a duty under the legislation for local authorities in particular to have a sufficient number of approved mental capacity professionals, similar to what they do at the moment for AMPS in mental health. It's critical for all frontline staff to be familiarized with liberty protection safeguards so they can explain liberty protection safeguards and the authorization record to the person and the appropriate person. You might want to think about transitional training for your BIAs and possibly for your existing supervisory bodies, those of you from local authorities, to responsible bodies and their new role. You will need to think about, if you're from children and families, all those who need to train up as approved mental capacity professionals. Is it worthwhile training up in the interim to be a BIA? I would suggest respectfully, yes, it is. You may need to start identifying what arrangements that you apply in delivering a particular service in your organization that amounts to a deprivation of liberty safeguard. That amounts to a deprivation of liberty under the deprivation of liberty safeguards that at the moment are not covered by it. So this is essentially what the ballpark is going to look like coming forward. For more information, these are some free links. Do feel free to take a picture of this on screen. You can go onto these first 2 websites where you'll get updates on case law, particularly in relation to mental health and the Mental Capacity Act. 39 Essex Chambers, they've got a newsletter. I suspect other legal firms, I'm not advertising that firm, but I'm mentioning it because they are pretty much hot in relation to mental capacity issues. And they're the ones who actually did the case of the Bonward case. And of course, it wouldn't be fair for me to do this presentation and not make a plug for our training that we offer at Middlesex University. And we are still going strong. So at this point, we've got a poll that I wanted you all to take part in. So if you can participate in this poll, that would be great. So the poll is now live. How likely is it that you are going to be involved in the implementation of the liberty protection safeguards? Oh, that's pretty.
All right. Okay.
Yes. Very likely, not likely. Okay, I think we've got a 50-50 split of very likely.
All right. Okay.
Unlikely. It's fluctuating. Okay. All right. So we've got now, and perhaps we could stop there and then deal with some questions, Niall.
Yeah. There's several. I'll put the questions into areas, really. They've had questions all the way through. The first lot of questions we're asking around two things, really. One is where LPS takes place, and there's interesting questions about family homes and what is reputable to the state. So there are questions around if a person is deprived of their liberty in the family home but is not receiving any care from anyone else, is that something that the local authority responsible body would then have to authorize or not? And I've said yes. And it would be difficult to imagine that somebody not getting any care in their own home that is not reputable to the state. I mean, they have GPs, they'll have some sort of services. So the general rule of thumb would be that if someone is being deprived of their liberty in their own home, then it will be subject to a LPS assessment. But if local authorities don't know, they don't know, so they can't really do anything. The next set of questions were around where is the responsible body, which authority, if you place somebody in your neighbouring borough. And at the moment, there's clarity, it's where the body is, similar to mental health legislation. That is slightly different for 16 and 17-year-olds. The government has given some sort of indication, it's about who's making the arrangements. And this, as ever, will be a source of dispute and clarification in the code of practice. There's likely to be local agreements made or in regulations or in the code of practice permission for local arrangements to be made. Otherwise, you could get some boroughs that are overburdened or suddenly, get surprises. So it'll be a similar sort of situation to now. It's about where the body is, but with some exceptions and then subject to change. The next lot of questions were around training for the new roles. Okay. Yeah. And I think you answered those as you went on. I mean, basically, at the moment, my understanding, Raman, is that the responsible bodies are responsible for supplying enough and for the transition arrangements, but no one's actually defined what enough is and exactly what those transition arrangements are. So that's another sort of vague area. I think
there is an interesting question, Niall, from Andrew, where he's asking, will BIAs have a fast track training or similar to become AMCPs? That's a very good question, Andrew. I can see why that would be very appropriate to take place, because as I pointed out, the knowledge to be an approved mental capacity professional is no different to what a best interest assessor has at the moment. So essentially, what is required is to understand what the new process is going to entail. And that can be definitely fast-tracked. It is something that we are certainly looking at Middlesex University, which is why we haven't revalidated our current BIA program to train approved mental capacity professionals. So watch that space.
Yeah, I mean, there will be something. A very similar process happened between ASWs and AMPs. So something will be there. There was another set of questions, or one or two, Raman, around someone refusing. And there's a really interesting question around, does it have to be the person themselves that's refusing? Could someone object on someone else's behalf? Which is kind of, that's an interesting question. Certainly, I mean, do you have any views about that? I do, Raman. Do you have
go on.
Oh, well, certainly it's not as clear cut as in, say, Mental Health Act, where there's a role of a nearest relative. But certainly we do have the role of a IMCA, independent mental capacity advocate. And if somebody is making an objection, when the kind of a rule of a thumb would be that you would then pass that on to for the LPS, the full LPS process and the assessments. It would be pretty risky not to do that if someone caring for a relative or closely involved with the relative is objecting to the deprivation. It would be very hard not to involve the full process of LPS and to do all those three assessments. So a rule of thumb would be do the assessments. The exact legality of who has what status in terms of objecting or refusing is not quite clear at this stage. Not as clear as say the Mental Health Act. I mean, What's
There
your
is an interesting question, Niall, I noticed from Dominique, who said, and I think you answered it, but if I may, I just want to add
Mm,
something to that in response. The question was for the group, how would the local authority become aware of these arrangements if they are not involved?
yeah,
And the point is, the local authority would become aware, particularly where the care arrangements or the arrangements in place is being funded by the local authority or it is actually being regulated. So, for example, you put in a care package for someone to receive X amount of input from carers. The local authority is invariably going to be involved and should be aware of these things. And this is where the frontline practitioners need to be really clued up. Because the carer may very well not, that is employed, may very well not have a clue about LPS, but the social worker who has arranged that care package would need to be.
yeah. I mean, certainly, and that's so certainly the idea of objecting to these arrangements. I mean, the person who's going to pick that up may be the carer going in, maybe the care coordinator, maybe brokerage in your local authorities. So there's a whole range of people that would pick up
Yeah.
the circumstances where there's deprivation of liberty. The bit about whether that person objects is a whole new sort of legal sort of issue, a knotty issue that's going to be the subject of lots of case law. And one could argue, for those people who are familiar with the history of DOLS and where it came from, one could argue that this might be a sort of retrograde step if we're relying on people to either assent or consent or object to their deprivation of liberty. There are some people who, what is active objection? Acquiescing and going along with something is not the same as agreeing to it, but it may not be not objecting. So that's going to be a big issue.
There is a question on what is a public body? And the answer is yes. For LPS to be engaged, a public body has to be involved. And that can be include people who are self-funding for their care, but that care that they're paying for, if that is coming from a regulated provider, then definitely.
So yes, so it's anything that's regulated by the state.
Yeah.
So that's pretty well everything, really.
Yeah.
Every care aspect.
I might have missed some questions. If there's any other questions, we are happy to take those.
Could you please send handouts?
Yes, slides will be sent to participants. I understand a recording. You'll have access to this recording as well.
Yeah, I can't see. It's very difficult not seeing everyone, isn't it?
Yeah. I see we've got a former student here, which is nice. Welcome. I won't call your name.
I've noticed.
Will these professionals need to become authorized through additional training, such as BIA training, or will all these professionals be able to complete these assessments? That's a brilliant question asked there. I won't call your name because I guess you want to remain anonymous. But that's a very good question. All professionals who are going to be involved in the authorization process will need to have some kind of formal training.
And I think that's
go on.
I think that's particularly relevant for workers who work in children and families. A lot of this is going to be very, very new, so that the idea of mental capacity might be new to you unless you're working in a specialized service, and the idea of making care arrangements and having to make an additional an assessment is going to be pretty new as well. The concept of deprivation of liberty might be new for some children and families social workers as well. So a lot of learning, a lot of arrangements within children's services, I think.
Yeah.
I'm wondering how people feel about this, because on the one hand, people might be thinking, "Oh, 2 years. A week is a long time in politics. 2 years in social work, you'll be hugely experienced by then." I'm wondering whether people are thinking, "Oh, 2 years, that's plenty of time," or were they thinking, "Oh no, we better we better hit the ground running and get some training now. I wonder what people are what's their reaction to the implementation of this. I wonder if it scares people or
there's an interesting question,
Mm.
Niall, that has come in. I just realized the questions at the top, the more recent questions. So it's about the assessment documents.
Mm.
This is one of the perhaps the bugbears about the Mental Capacity Act and the subsequent legislation, in that, unlike the Mental Health Act, where you have very, very clear statutory assessment documents to complete, assessment documents under the Mental Capacity Act are not statutory. So at the moment we are actually waiting on the Association of the Directors of Social Services to make a recommendation in relation to what these assessment documents are going to be like. And usually they would have some suggested performers that they would put up. But in the meantime, if you're doing mental capacity assessments, you use what is used in your organization.
Mm.
And brilliant. That's a quite excellent point that Jenny, you were raising there, because indeed every single piece of legislation that's been passed since 1970 has involved more and more responsibilities being passed on to local authorities. And of course, local authorities is the named organization, and they simply delegate it to their social workers. And in the NHS, that's going to be nurses. So definitely, and in light of the reducing budget for local authorities, you can see where, as I say, how long is a piece of string kind of thing. It's going to be getting very, very tricky. Absolutely.
Yeah, we've had some comments about, this is another bit of legislation, another role, another thing that's got to be added on to a very busy life. And I can certainly empathize with that. And so now is the time to be asking, your authorities, your employers for support with this. There's one question saying, will this training be considered as relevant?
Maybe I should answer that.
I don't think it's meant in a very polite way, I think, Raman. Yeah.
Yes. I think you yourself would be very disappointed if it is, because there's so much there that needs to be understood. What is a deprivation of liberty itself? We have been running, certainly I've been involved in running Best Interest Assessors course for the last 6 years at Middlesex University. And we get people from all over the country and a wide range of responsibilities, including managers, people from CCGs, etc. One of the things that is rather shocking to Niall and myself is how many people are doing all sorts of things for mental capacity assessments and for best interest assessments that has absolutely nothing to do with the legislation. So, and that is something that the CQC have actually identified, and they have been doing so since 2014, that the understanding of the Mental Capacity Act among frontline practitioners remain a continuing concern for them, because it's 14, 15 years now that we have had the Mental Capacity Act. It passed in 2005, so that's just about 21 years. So you can see people still don't know how to do Mental Capacity Act. You still have people talking about the gateway to the Mental Capacity Act. There's no gateway. It's either you are 16 or above, in which case the Mental Capacity Act applies. So someone is asking, does the mental capacity assessment not statutory when we have a duty to safeguard vulnerable people?
I don't quite understand that question. I wonder if they could put it.
If I understand you, Abdirahman, what you are actually saying, it is statutory. Anytime you are intervening as a public body or representing a public body in the life of someone, and you're taking actions that they are not consenting to and lack capacity, then the Mental Capacity Act applies. Not to intervene or to take action on behalf of someone, even if it is to safeguard a vulnerable person. If you do not follow the principles of the Mental Capacity Act, you will be held liable. And the relevant case law for that, you can Google that. This piece of case law is the case law of ZH versus the Metropolitan Police. The Metropolitan Police was actually ordered. They were found to be in breach of the legislation. They did the right thing, which was to safeguard an autistic young man from actually going in deeper into a pool and drowning. But they actually did not follow the process of the Mental Capacity Act, the principles of the Act, and they were fined £75,000. So just be mindful. You can do the right thing and still be wrong if you don't follow the legislation. So that piece of legislation is ZH versus the Metropolitan Police.
It's certainly useful to review, for all of us to review our understanding of the Mental Capacity Act. I mean, it's a little bit like the Mental Health Act in terms of you've got to continually look at it. If you looked at it once 5 years ago and then just carry on, you need to relook at it and keep an eye on the case law, so that the websites at the end of these slides are really, really useful to keep a constant eye on case law. I don't mean constant by every day. I mean once a month or so, have a look at it.
If you sign up for the newsletter, as suggested, or from any other preferred legal chambers, you would be able to get regular updates. 39 Essex chambers, they send it out on a monthly basis, and you can just look at what is relevant to your area of practice. Nobody is expecting you to read every single piece of case law. That's absolutely impossible.
And certainly there's going to be major changes for care arrangements for 16 and 17-year-olds who their totality of their care arrangement may amount to deprivation of liberty. So that's going to be quite a major bit of work for those working in specialist teams. So it may not just be residential. It could be the whole care package that a person gets. There will be elements of that where they could be deprived of their liberty. And so that's going to need some thinking, some auditing as well.
I would certainly think as well that, local authorities, in particular NHS bodies, will really have to be mindful as to who actually will be in their responsible body to be making these very weighty decisions. And to be clear, because there's a question about liability, which I think also frontline assessors will need to be mindful of. And this might be a good point for you guys to consider getting yourselves indemnity insurance to make sure that you can't be sued personally. I won't say any more about that, but I'm happy to respond to people who might message us privately in relation to getting indemnity insurance.
So, there's another question. I thought you said mental capacity assessments were not statutory. I think we might have confused someone there.
I think he was responding to what I was saying. So he was under a different impression.
All right. Okay.
So he's just clarifying. Yeah.
All right. Okay. I thought. Yeah. All right. I see. So I hope you realise that they are statutory.
Yeah. So we've just got about 17 more minutes for this presentation. I am happy to continue speaking. I'm sure Niall is as well, because this is like our bread and butter issue. Our next run of the Best Interest Assessors course. In fact, just a moment ago, I saw an email coming through saying, could you approve this application? So people are furiously coming in. And amazingly, we are getting people from all over the country. And surprisingly, not many people from within London who are being funded by their employer, which is quite shocking, really. So that's another thing that people might be thinking about. Is it worth doing this course privately? Is there going to be a need for independent approved mental capacity professionals? And I would say there's very likely to be, just as there is likely at the moment for approved mental health professionals who work with different agencies and are employed to carry out those mental health act assessments. So
certainly it would be worth children and family social workers to come on a BIA course. That'll be a really good preparation. If you can persuade your funders, that would be very useful for you. That would be fast track training. It's 5 days, quite intense. People kind of get a lot out of it. So if you're a children and family social worker, then you'd get quite a lot of intensive training in 5 days, and then you have to go out and do an assessment and reflect on it and write something. So it's quite a rigorous, intense course of 5 days.
Yes, it is.
And
so at this point, it's now we are 1 hour 15 minutes into. Please be mindful. You will be receiving copies of the slides after the session, and also a link to the recording of this session, so you would actually be able to recap everything that you might have missed for those people who came in late. So at this point, Niall, I think we can thank our audience for attending.
Absolutely. Even though we can't see you, but and how many are here, Raman?
We've got 19 people. One person had to leave.
We've increased them. That's great. So to our ex-students, we've seen you. Thank you very much for attending.
There was a current student as well.
A current student as well.
A current student as well. Thank
good.
you very much for attending.
It's always lovely seeing students that are going out.
Guys, hope to see you all soon, and do go out there and protect people's liberty.
Yes, absolutely. We can wave. They can't wave at us. Okay, thank you, guys.
Bye.